Wait. Is Dr. Andy already here? Ayan, Dr. Andy is here. Captain Andy. Good afternoon.
Okay. Hi, good afternoon, Professor Celso, Dr.
Yes.
Harry.
Good afternoon. Andy.
Good afternoon, everyone.
And how is the weather in Manila?
It's kind of, I think, not so sunny, but I mean, there's also some possibility that it will rain today. Yeah. Where is the? Oh, yeah, here. We are already live stream in Manila Times Facebook page, and I'm now sharing the live stream to different groups and also on my Facebook page.
Fine, thank you.
Welcome.
Anyways, in organizing these meetings. Right now, I'm not in Beijing because it is summer vacation. I bring the kids to a southern city in the mountain area, so it's a little bit cooler than Beijing.
Oh, I see. Yeah, I think so. I mean, some friends told me that it's like hot, kind of hot in Beijing.
Yes, a little bit.
Integrated, okay. Okay. Platform before we start, so that's why if there was a sound, but I think I. We have before we start, so we have few minutes to chit chat.
Yes, I have just connected Mr. Yang Li. Other two.
When should we
alright.
have a group photo?
Okay,
Okay.
that's fine.
Oh.
Yeah.
Okay, let's start. It's 3 p.m. So it's just the right time. So let me welcome everyone. Okay, ladies and gentlemen, good afternoon to everyone, to our esteemed and distinguished speakers, and to all those people who are part of this webinar, and also those people watching and participating via live stream on different social media platforms, especially on the social media platform of the official media partner of this webinar, the Manila Times. Good afternoon, and thank you for attending and participating in this very timely and very important, I think, webinar on oil and gas joint development cooperation between China and the Philippines. To give us an opening remarks, may I call on Captain Andy Shi Chen, founder and president of Global Governance Institution. Captain Andy, you have the floor.
Thanks, Anna. Good afternoon. On behalf of the Global Governance Institution, a warm welcome to both old and new friends and the media platform friends, in particular our co-organizers from the Philippines, the Asian Century Philippines Strategic Studies and the Integrated Development Studies Institute for their valuable contribution and support. I'm retired Captain Andy Chen, founder and the president of the Global Government Institution. As an independent non-government international think tank, we have always been devoted to encouraging open, frank, and thought-provoking discussion and debates on significant issues that concern both China and the global stakeholders. Sino-Philippines relationship is surely one of the most significant issues as such. In neighboring relations, since neighboring relations is always vital among China's foreign relations, as one of the series of China-Philippines dialogue at the NGO level, today we are going to focus on oil and gas joint development cooperation. Since taking office, His Excellency Mr. Duterte, the former president of the Philippines, has decided to leave aside the South China Sea arbitration on hold to improve relations with China. On the ground of that, Manila and Beijing signed a memorandum of understanding on oil and gas development cooperation in 2018, and held the first meeting of the Philippine-China Joint Steering Committee on Oil and Gas Development Cooperation in 2019, agreeing to further promoting communication and coordination on oil and gas development for mutual benefits of both countries and their peoples. And then on June 23rd, 2022, the outgoing Philippine Foreign Affairs Secretary gave a statement about the oil and gas discussion between China and Philippines. And such statement has triggered concerns from both sides. First of all, the bilateral cooperation on joint development of oil and gas and related discussions, negotiations, is a consensus reached between the two sides, from presidents and the high-level ministers of the two countries to working groups at operational levels across a whole range of fields and disciplines. Both countries have carried out a lot of detailed work and made concrete efforts to ensure a legal and transparent bilateral cooperation that would benefit both sides. There was consensus and accomplishments credited by the two sides. Given the above tremendous efforts done by both sides at all levels, how will the current government take this? The key question is, will the tremendous efforts and accomplishments of both governments be offside or wiped out by individual statements? Given my own long-term experiences as a military diplomat, I think we need to adopt an objective understanding of the role of diplomatic talks in managing maritime disputes. A number of international practice reveal that since sensitive diplomatic negotiations would involve political, diplomatic, security, and other complex factors, it is expected to go through a long and tedious process with prolonged delays and uncertainties before a remarkable consensus could be achieved. At the very last sense, it is worth clarifying that the current situation, in particular, the successful efforts from both sides to maintain effective communication, is in itself meaningful outcomes. So how to take this issue forward? For my own understanding, certain suggestive points for us to keep in mind. First, both sides should respect the consensus already reached. Second, resolving the differences between China and the Philippines, and also between China and other countries through diplomacy and dialogue, maximizing bilateral consultative mechanisms and multilateral mechanisms through the ASEAN level, without affecting the two countries' respective standpoints on sovereign and territorial issues. Third, to focus on a substantive and a technical issue rather than on politics, while striving for cooperation and goals and sustained progress step by step, hopefully reaping early harvest. Last but not the least, to take active attitudes in carrying out a constructive dialogue with strategic visions to promoting development cooperation projects and to proactively address the difficulties and challenges faced both independently and collaboratively. One of the GGI slogan is, "The impossible missions are the only ones which succeed," because we think that only difficult and challengeable things are meaningful. It is in this spirit that Anna and I initiated this dialogue to get together a group of serious scholars to share their perspectives on this very important topic. It is expected that the discussion of those above questions could lead to some policy recommendations for both sides. Without further delay, please allow me to first invite on Chinese side Professor Dr. Zhiguo Gao to share his views. Professor Gao is the president of Chinese Society of the Law of the Sea, a former judge of Ito's professor of Chinese University of Political Science and Law, and also as well professor of Dalian Maritime University. Just go the floor is yours. We expect each speaker to make their remarks within a maximum of 15 minutes. Thank you. Please, the floor is yours. You need to share the screen of your PPT. Hello, Professor Gong. Anna, maybe we can...
Probably we can move to Dr. Henry before Professor Gao, because I think he is not in front of his computer.
Yeah, please, go ahead.
Oh, yes. Okay. Dr. Henry, let me introduce Dr. Henry first before I call him. Dr. Henry Chan is the Senior Visiting Research Fellow of Cambodia Institute for Cooperation and Peace. He completed his university degree in engineering from the University of the Philippines and also MSc in biopharmaceutical from the University of New South Wales and PhD in management from Singapore Management University. Dr. Chan's research interest is Chinese economic development, ASEAN and China relations, technology and economic development. Dr. Henry, please proceed.
Thank you very much, Captain Tian and Anna, for having me here in this very important webinar. I have not prepared my PowerPoint, and my contribution is I want to look at this issue, both the territorial dispute and the issue of oil and gas corporations from a historic and economic development point of view. This is a little bit unusual, but I hope that it can add value to this webinar. First, from the historical perspective, let us realize that territorial dispute is older than the notion of statehood. Even before human civilizations, we already have people fighting over territories. So it's right to say that territorial dispute is actually longer than human civilizations. But after we realize this, we have to ask the next question. How come until today, we don't have very satisfactory solutions on these centuries of problems? Now, historically, territorial disputes were settled by peaceful means or non-peaceful means. But I think everybody realized, very unfortunately, the non-peaceful means actually dominate human history in solving territorial problems. So this is something that we have to take in mind. If we don't take this thing carefully, this thing spillover effect can be very serious. Now, among cases settled by peaceful means, third-party arbitration is a very rare occurrence. and it only covers very minor disputes. Most peaceful settlement actually involves bilateral negotiations. In this regard, you'd be surprised to know that China has been the most active in recent history in settling peaceful settlement disputes. China has the longest land border in the world. It runs more than 22,000 kilometers. And it has successfully settled more than 18,000 with 11 neighboring countries by negotiations. Only 3 countries China has not settled the border delineations: India, Pakistan, and Nepal. Now, why we bring this point up is that if you look at historical lessons, that bilateral negotiation is the dominant mode of the territorial settlement. Now, it reflects just simple that any territorial dispute is an emotional issue. It's already not an issue of legal right or wrong. It's already that people are attached to the place that they think belong to them. And of course, the other thing is that it's very hard. And right now, there's no satisfactory settlement rules. Now, only by bilateral negotiations, both sides can be happy. In fact, most of the countries refuse third-party intervention. If you look at human history, talking about territorial settlement. Now, third-party arbitration is always very difficult. If you look at these angles from the history of territorial dispute settlement, actually, this issue belongs to the realm of geopolitics and diplomacy, more than it depends on any legal framework that you can think of. I'm talking about history, and these are all facts that everybody realized. And right now, if we talk about why no third-party settlement rules is satisfactory, you must understand that the present international law overlooks the fact that you have issues of heritage, you have issue of cultures, and you have issue of emotions inside any territorial discussions. Now, right now, when people talk about that, there's no such thing historical claim. They just forget. If you look at the case of Israel, this is the best case in the world human history that the historical claims does matters and does counts. And of course, it's very important that why historical is being belittled. Because if you look at the colonial history, like in the case of the Philippines, when the Spaniards came, they just declared the whole country under the king's rule. And that is where the hacienda history started. All the native barangays, communal land, were declared null and void. So the issue that the historical claim is not a valid issue, carry a lot of judgment calls. Now, of course, we talk about peaceful means, we already settled that. Based on human history, bilateral negotiation is the mode. And if you are not very careful, it can easily split into non-peaceful means. Now, if you look at the non-peaceful means of territorial claim, you realize that it is actually always the result of a war. And then after the war, there's always a peace talk. And the subsequent peace treaty just legalize whatever the victor's claim is. Now, if you remember the statement, whether attributed to Winston Churchill or wrong, that history is written by the victor is a very, very sad, but a very, very historical true statement. Now, after this, let us look at the modern warfare. If you look at what happened today in Russia and Ukraine, and I think today is getting to 150 days. Now, there are now 6 forces operating in this new era of fighting. You have the traditional land war, sea war, air war, and then you have these nuclear strategic warfares. And right now, you can already see that we have cyber warfares and space warfares. So the war today is getting very, very complicated. And after looking at this, you realize that how many countries can afford to fight this kind of war? And everybody knows that the 2 top contenders is the United States of America and the People's Republic of China. Now, if you look at the widening gap between the military powers and the other countries, because of these industrial revolutions, which is actually have all the precedents in the early industrial revolutions. They, in each industrial revolution, you have new military power emerging. Now, it's very sad for other countries. If you look at this war, we have the autonomous weapons now being come in, the drones, and you have precision weapons, the HIMARS. And if you look at all this, you realize that the cost of war today, actually for those military powers, is getting lower and lower because human casualty is being cut. But for the other countries, it is getting more destructive. You just look at the footage of any Ukrainian cities. You know what that means. They live in rubles more than any other thing you can imagine. So it is very important that with this a territorial dispute, which is always happening in human history, we must look for peaceful means of resolving it. The cost of war today is just too much. Now, very luckily, what happened between China and the Philippines is maritime territories. And again, if you look at human history, resolving maritime territorial dispute is a lot easier than the land dispute. And the reason is very simple. Because if you look at the sea dispute, always the center is on resources. Of course, number one thing is always fishing. And right now, of course, with this UNCLOS, you have the mineral rights and you have this oil and gas. Now, another thing is that in the sea territorial dispute, because it's not really where the people live, the attachment to the sea is much less than the attachment to the land. So many people actually don't consider the sea dispute as a challenge to national patrimony. And that is very important. Now, if you realize that, I'm sorry I did not prepare the slides, but I shared it with Anna, is that even though one of the biggest gas field in the world between Qatar and Iran is cut across the boundary, and they have worked out a means to share all the gas recovered. This is one of the biggest gas field in the world. So if you look at the Mediterranean seas, they have a lot of islands, and how they look at the fishing right. So they have very peaceful means of resolving it. So this one actually brings us to the issue of, if you take a look at oil and gas as an economic interest, and maritime territorial is more about economic interest, this should form a very background to the peaceful resolution of the current issues. So if you look at our webinar topic, oil and gas joint development corporations, I think that if the mechanism can be worked out well and explained properly to the people, there is a chance that you will have public support. So I look at the angles from the historical perspective, because I must admit, I'm never an expert in geopolitics, law of the sea, law of the oceans, but I just look at things of what had happened before in human history, and I hope that that can help. Now, after looking at it from the historic perspective, let us look at it now from the development economics perspective. Because my profession, I'm trained as a development economist. And of course, when you train as a development economist, there's a heavy dose of historical precedents that I study. What really happened to those countries who succeeded in economic development, and who are the countries who failed in economic development, and what are the lessons that we can draw? Okay, the first question I want to pose to the audience is this. Everybody now talk about the weather. China this year is a very abnormal weather. Many places is over 40, and then you have floods in somewhere. And Europe, in the US, is scorched earth, okay? So many countries over 40 degrees. Now, the commitment to climate is definitely something we cannot get away. If the climate changes proceed at this rate, human civilization is going to change dramatically. Our survival is at stake. In fact, Southeast Asia is in a very difficult situation. I studied this climate change and must tell you that if you go to Navotas today, you know how many places can easily get flooded in the high tide, okay? The ocean is really rising. The water is intruding. Now, this question is this. So many countries now commit to so-called zero carbon emission by 2050, 2060. Okay. Now, you know that one of the biggest economic victims of carbon neutralization is oil and gas, because they are the one producing the carbon dioxide that warm the planets. So if you realize that, I pose this question, shall we exploit the oil and gas today when they are very valuable? Because right now in Manila, everybody is suffering from this high price of gasoline. But you can already foresee, over the long term of 20, 30 years, oil and gas importance to global economy is going to be diminished, whether we like it or not, because we have no choice but to phase them out. So, number one thing, are we going to fight over an asset that the value is diminishing by emotions? Very objectively, from development economics point of view, let us be realistic. Get them out first off the ground and help the economy as soon as you can. Now, everybody knows that military expenditure is a consumption and not an investment in most countries. Only those countries who build arms, like the Nazi Germany, need an arm industry. Most of the others who buy arms realize that military expenditure is a waste. That is why you have a classical saying, economics, a choice between gun and butter. You can only choose one. Okay? Now, it is without dispute that all countries need a very peaceful environment to focus on economic development. It is a reality that a benign external environment is a necessary condition for economic development. And I think in the case of China, nobody talked about it more often than Mr. Deng Xiaoping, who initiated the reform. Now, however, we know that a benign external peaceful environment is a necessary condition for economic takeoff. But this alone is not sufficient for takeoff. If we want economic takeoff, we need corresponding domestic reforms. Whatever the gas and oil and gas bonanza can bring you cannot alone to move the country forward. This is one point we have to explain to the people. We need a necessary international benign environment. We want capital money coming from the oil and gas, but we must also work hard. Okay. Now, there is a story I want to suggest both the Filipino and the Chinese audience take a look. If you remember, in 1960, South Korean per capita GDP was only 60% of the Philippines, 1960. But today, South Korea per capita GDP is 10 times the Philippines. So in the economic takeoff of South Korea, we have a story called the miracle of the Han River. Now, Han River is the river that cut across Seoul. If you look at the miracle of Han River, the normalization of Japan-Korea relationship is play a very important role. So there was a treaty that President Park Chung-hee signed in 1965 with Japan called the 1965 Korea-Japan Normalization Treaty. That one played a very important role. And if these oil and gas explorations can bring similar benefit to the Philippines, I think all Filipino peoples would love to have it. Okay? Now, there's so many details in this. But again, the miracle of Han River is available in Wikipedia and everywhere. Please look at it and see how the whole process runs. Now, I must say this way. The treaty remains a little bit controversial today because all those comfort women, all those forced labor issues in the Japanese colonial history in South Korea were absorbed under this treaty. But this treaty did bring tangible effect, benefits to the South Koreans. Now, and again, this miracle of Han River, personally, I believe, is a very good example of how a good external relationship helps jumpstart a country. This is very important. We have to learn from history, how others did it, how are we going to replicate it, and modify to suit our conditions. Now, President Marcos is very right to point out that the relationship between China and the Philippines is a multidimensional one, and we should focus on the positive sides. However, I must caution you the framing of the 1987 constitutions, ignoring the difference between territorial water and exclusive economic zone, will always make the president's legal position not as strong as you like. Now, in these constitutions, you must remember under UNCLOS, every country has 12 nautical miles of territorial waters. But the 200 nautical mile refer to exclusive economic zone. So that means from the 188, from the 13 to 100 to the 200, the country does not exercise exclusive sovereignty. It just has control over economic interests. But unfortunately, in 1987, legal experts do not look at this issue very closely. So I have seen that in the initial negotiations, everybody talk about sovereignty. So I'm sorry to point this thing out, and it's very unfortunate. So it is very important for the whole issue being discussed openly, with all the legal argument and economic argument being put forward very carefully. And I'm sure that the citizenry will support an enlightened government to have this idea pushed forward. Thank you very much for your attention.
Thank you very much, Dr. Henry. By the way, ladies and gentlemen, Dr. Henry is also the adjunct research fellow at the Integrated Development Studies Institute. So if you listen to Dr. Henry, he is trying to lay ground the historical, somewhat historical perspective to the issue of territorial dispute and in relation to the oil and gas joint development cooperation between the Philippines and China. Vis-a-vis the disputed South China Sea, because that's where it's supposed to be located. So what he's just saying is, that, there's a need for this oil and gas development to proceed, but at the same time, there are a lot of things to work on between the two countries. And another thing that I think is very important that I want to point out with Dr. Henry's talk is that bilateral negotiation is the way to settle territorial disputes. So without further ado, I will give the floor back to Captain Andy for the introduction of again of our next speaker or previous speaker supposedly. Captain Andy.
Thank you, Anna. A very impressive, Dr. Henry. I think that if we grasp the opportunity, the time between China and the Philippines could become a golden period. If we lost the opportunity to develop ourselves, it would be unfortunate. Thank you. I have introduced Judge Gao as I reintroduce him again. Please, my assistant, would you please help to share the PPT on the screen? Professor Dr. Zhi Gao, he's the president of Chinese Society of the Law of the Sea, former judge of A12, professor of Chinese University of Political Science and Law, and as well professor of Dalian Maritime University. Judge Gao.
Yes.
Please, the floor is yours. Would you please?
Thank you. Thank you, Captain Tian. Let me try to share my PowerPoint with you. Let's see. Can you see my PowerPoint?
Not yet.
Not yet? Okay, let's just give me a few seconds.
Take your time.
Okay, let's share my. Is this time okay?
Yes.
Okay. Dear Anna and Andy, we have two Anns here, and distinguished panelists, distinguished attendees online from both China, the Philippines, and perhaps a third place elsewhere. Good afternoon. First, I'd like to commend the two organizing institutions from both China and the Philippines to organize this webinar on oil and gas joint development cooperation between China and the Philippines. We all understand that the Sino-Filipino relations arrive at a new junction, in the sense that there is a new administration in the Philippines. And of course, worldwide, we have a general world backdrop, and that is the conflict in Europe between Russia and Ukraine. So this dialogue is really, in my view, is really timely, very necessary, and very important, and for both of us to move forward. I feel very honored to be included in the program of this webinar, and I also feel excited to once again touch upon with other panelists on one of my favorite topics in my professional career. I will move forward in 4 brief phases, and I'll speak roughly for 20 minutes. About 30 years ago, I was teaching in a British university. The reason for me to move on from US to teach in the UK is that my PhD supervisor told me, and he said, I quote, "If you have taught in a British university, you can teach anywhere in the world," unquote. So this is why I went. During my teaching time, I published my first book in English, entitled International Petroleum Contracts. This is why I say one of my favorite topics. The book has been published for the last 30 years, and it still sells at a very strong price, $450 a copy. The other thing I wish to mention or share with the panelists is that roughly 25 years ago, I published an article entitled "The Legal Concept and Aspects of Joint Development in International Law." I have an electronic copy with me, and if any one of you wish to have a copy, and you can email me or WeChat me, I will be able to circulate this to you. Let me go back. Bear with me. Another thing I wish to mention to the Filipino colleagues is that we both countries started our negotiation or consultation on joint development roughly 20 years ago. I have a set of PowerPoint dates back to 2002, March 5th and 6th. This initial official dialogue, we could also call negotiation between China and Philippines, was organized by the 2 foreign ministries, and the Chinese team was assisted by a group of experts headed by me. And this is the PowerPoint I presented at the initial, if not the first, dialogue or negotiations between our 2 countries. And finally, as an introduction point, I want to touch upon the 2018 Oil and Gas Memorandum between China and the Philippines. And that was signed on 22nd November 2018, when His Excellency, the President of China, paid a state visit to the Philippines. And the MOU also authorized to establish a joint steering committee. And over the last couple of years, in particular in 2019 and 20, the Joint Steering Committee and the oil industry representatives from the two oil companies from both sides worked intensively to negotiate and produce a series of contractual terms and conditions. So those are some of the background information, and then I move on quickly to my second phase. That is, I wish to say a few words on international law. The concept of joint development is a new, relatively recent notion and began in the 1960s. And the trends towards acceptance or in-state practice accelerated since 1970s. There is no official or consensus on the definition of joint development. I attempted to arrive at an academic definition in my article, and I stated joint development as the common exercise of sovereign rights and jurisdiction. Now, common exercise, sovereign rights and jurisdiction. It's not a unilateral exercise based on an international agreement for the purpose of exploitation and apportionment of a potential natural resources in an overlapping area of territorial disputes pending delimitation. This personal definition embraces or embodies 5 key elements. The first one is there must be a dispute. Of course, there must be natural resources, non-living resources. There are need and governmental, intergovernmental agreement. For the purpose of joint operation, it is finally a transitional in character. It's not a permanent, it's not a final resolution. Although the notion is of relatively origin, but the concept or the principle deeply rooted in both conventional international law, customary international law, international adjudication, state practices, and principles, soft law or principles, general principles of law. Let's have a look at the conventional international law. We refer to Article 7483 of the Laws Convention. It reads, binding agreement as provided in paragraph 1. The states concerned in a spirit of understanding and cooperation shall make every effort to enter provisional arrangements of a practical nature, and during this transitional period, not to jeopardize or hamper the reaching of the final agreement. Such arrangement shall be without prejudice to the final delimitation. So this is the conventional international law. Let's move on. In the interest of time, let's move on. One of the, I'd like perhaps to mention 2 features of this treaty provision or articulation. The first major point is non-prejudice. It's non-prejudice to the pre-arrangement position or final delimitation. This is very, very important. And also, in my view, the Article 74 and 83 in general, or more specifically, concept or principle joint development, or to say temporary arrangement, is in nature both incentive and prohibitive. It is prohibitive in the sense that it prohibits any unilateral action or movement to the damage or to the prejudice of the interest of the other side. It is incentive in the sense it encourages both parties to negotiate in a spirit of understanding and cooperation for any form of temporary arrangement of a practical nature. Let's move very quickly to state practice. And let's look some of the, I have a table here. We're running from the very first one in 1965 between Saudi Arabia and Kuwait. It's a joint development agreement in the neutral zone in the Persian Gulf. And then winding down to the list, at the end of the list, we have two Asian examples. Number 7, the Thailand and Malaysia Memorandum on Joint Development in the Gulf of Thailand, and the 1990 and the Timor Gap Treaty between Indonesia and Australia in the Timor Sea. We will not go into any details of these state practices, since I think we know most of them. But we move very quickly and to see some of the Chinese practices, and China and Japan signed a fishery agreement in the East China Sea in terms of joint cooperation development of non-living resources fishery. Another agreement is South Korea and China in the Yellow Sea, and also is a fishery agreement. A third one is the Sino-Vietnam Maritime Boundary and Fishery Agreement in the Gulf of Tonkin. Finally, we have the Sino-Philippines MOU and joint development negotiations since 2018. As I said, the steering committee held a number of rounds of talks, and the industry representatives from the oil companies from both countries went on intensively to deal with some of the concrete contractual terms and conditions. I think the negotiation between China and Philippines in the current round is much broader and in-depth than the previous agreements, since it touches upon very concrete and detailed aspects of oil and gas development. Now I have about 5 minutes to go. Let's quickly jump to some my final part of the presentation, some findings and conclusions. Joint development has been on the rise over the last 40 years. It covers both living, non-living resources, as well as perhaps other forms of natural endowment. One of the things I like to stress is Southeast Asia. South Asia produces some of the finest models in terms of joint development. The first one is between Malaysia and Thailand. And the second one, perhaps we could mention, is that between Indonesia and Australia. Yeah. It proves that joint development is a workable approach to complicated territorial disputes and sovereign issues. In my understanding, the very secret for the success of joint development depends very much on the genuine political will. Wills, plural forms here. It's not the will of one party. It needs the wills of both parties. The 2018 MOU between the two sides is a legal document of a treaty nature. If you read, it's an official, it's a intergovernmental MOU. It's an international legal instrument. It's not a political sort of a declaration. Yeah. And the work of the Joint Steering Committee and the contractual negotiations by the oil companies demonstrate the spirit as provided in the convention, the spirit of understanding and cooperation of our two governments. Yeah. As I recalled to you in my opening PowerPoint, the initial talk between our two countries started, to my best knowledge, in 2002. 20 years has flown over. So it takes us 20 years to arrive at the present stage of oil and gas joint development cooperation. It's not an easy task, dear colleagues, dear friends. 20 years, almost a time of a generation. Yeah, it's painful. Both China and Philippines are parties to the United Nations Convention on the Law of the Sea and oil and gas cooperation development. Or, in other words, temporary arrangement of a particular nature is a treaty obligation for both China and the Philippines under Articles 84 and 73 of the Convention. So we have perhaps we have a two set of rights and obligations here. And one set is the treaty rights and obligations under the Laws Convention for both countries. The other set of rights and obligations is under the MOU. It's the intergovernmental MOU signed in 2018. I wish to issue one warning as well as one call for my conclusion. The warning is that it is unrealistic, if not naive, both politically and legally, for either side to expect a rollback by the other side from its sovereign and territorial positions or policies or constitutional provisions. Neither China nor the Philippines. Yeah. It's not realistic to expect the other side to give up completely. No, my second point is that it would constitute a major mistake. It's not a pity, it's a major mistake for both sides to retreat from the 2018 MOU and the subsequent negotiations of what we have achieved with mutual painful efforts in a period of over 20 years. So we made one step forward in 20 years with the mutual painful efforts. It takes a little time or zero time for us to roll back. Yeah, and we can roll back today or even tomorrow. Yeah, and that is really a pity, a major mistake. Yeah. Finally, my call is still pending any agreement or a final resolution. Temporary arrangement in a spirit of understanding and cooperation represents in the South China Sea. And with that, I conclude my presentation, and thank you for your time very much.
Thank you, Judge Gou. Judge Gou helped us recall the history of the bilateral talks, and also with his deep academic ground, help us to understand the legal foundations of the joint developments. Thank you very much. And also, at your conclusion, the warning and the points you mentioned. Thank you very much. And without further delay, Anna, I will turn it over back the floor to you.
Captain Andy, I think it's you who will introduce the third speaker. But before you introduce the third speaker, I think one of my takeaways from the presentation of Professor Gou is that I think very, very important point that we all need to understand, I think, especially our leaders in both countries, is that the success of oil and joint development cooperation, or any cooperation for that matter between the two countries, especially on the disputed South China Sea, is, I think, that both governments will have strong political will to pursue in the context of mutual understanding and benefit for both countries and their peoples. I think that's one thing that I absorbed, and I got strongly from the presentation as well of Professor Gou. This along with the many other knowledge and information that I received and I got from his presentation. Captain Andy, please introduce the third speaker.
Quite agree with you on your comments. And now, please allow me to introduce our third speaker, Mr. Li Yang. He's the Executive Director from the Institute of China European Studies, ICES. Mr. Yang Li, please, the floor is yours.
Thanks, Captain Andy, and thank the co-hosts for organizing this very important event. And good morning and hello to everyone from Brussels, because ICES, the Institute for China-Europe Studies, is a Brussels-based think tank, so with a focus on China-Europe's relations. So when I'm here talking about oil and gas cooperation between China and the Philippines, I do it more in my personal capacity, using the experience from my past service with China's Ministry of Foreign Affairs, as well as with my research in the National Institute for the South China Sea Studies. And with regard to the general situation of China-Philippine relations, as pointed out by many commentators, President Marcos is expected to continue with a balanced and pragmatic approach in Philippines foreign policy. And we could see that China and the Philippines have already agreed to develop a better and more robust relationship. And they also agreed that in this very important bilateral relationship, the South China Sea issue shall not be the mainstream. So it is very promising. But however, this does not imply that the South China Sea issue is no longer important. On the contrary, it does indicate that both countries, both sides, have to address this issue more carefully and in a more responsible manner. And oil and gas joint development is one of the issues that still need to remain on the agenda, so which comes to our topic today. I would like to make my comments from three perspectives, by looking down, looking back, and looking ahead. And my first point is from looking down to the bottom or to the root of this issue. The reason why the subject of oil and gas joint development comes up is that China and the Philippines have disputes in the South China Sea. And those disputes are territorial in nature and in origin, only later extended to maritime rights and jurisdiction as the 1982 United Convention on the Law of the Sea entered into force in mid-1990s. Oil and gas or fisheries, this kind of contests over resources often appear on the headlines, but they are only symptoms, not the root cause. The root cause is territorial disputes. And such kind of disputes exists in many parts of the world. South China Sea is not a unique case. On the other hand, we can find that nowadays, when people talk about South China Sea, they often approach this issue from the perspective of geopolitics or economic development. And this is fine. But when doing so, they shall not ignore that the territorial disputes are at the root of the case. And these disputes have a profound influence over all the current troubles in the South China Sea. And because the territorial sovereignty is at stake, neither China nor Philippines has any room for compromise. Some statesmen from the Philippines said that this country had no intention to surrender even a particle of sovereignty. And in fact, the same attitude applies to Chinese government. So the issue of territorial sovereignty is too sensitive and too difficult to be resolved within the foreseeable future. Maritime boundary delimitation might be a different story and supposed to be easier. However, with territorial disputes pending, there is always a lack of conditions for the delimitations to be concluded in a short while. Under such circumstances, the only logic applied in these disputes, as it is applied to disputes in other parts of the world, is that transitional or provisional measures are always the best option to address the issue. For example, as far as the maritime boundary delimitation is concerned, the United Nations Convention on the Law of the Sea also provides for such arrangements. And Judge Gao just now has read the text of the provisions in detail, so I will not repeat it. And Judge Gao is also right to stress that such transitional or provisional measures are not final solutions. They only create certain conditions or environment which are conducive to the final settlement. Or at least, they create a sense of direction, a sense of predictability and confidence that both countries could proceed on the right track with their bilateral relations, and that relationship would not be derailed by such disputes. Of course, agreeing on these measures might not be an easy task. It will take time, but it deserves working upon. So this is my first point. And then my second point is from looking back over history. China and the Philippines disputes in the South China Sea started in early 1970s. At that stage, we can find that the disputes did not compose a major trouble for the relations, since both sides had a more important and urgent agenda to attend to. In mid-1990s, temporary tensions erupted around the Mischief Reef. However, a series of bilateral dialogues helped cool down the situation. And later, a Declaration of Conduct of Parties, a DOC, was signed in 2002, and which gave fresh impetus for the claimants to seek amicable solutions to the disputes between and among themselves and pursue practical cooperation at sea. It was under this background that China and the Philippines, the national oil companies of the countries, with the endorsement of their respective governments, successfully entered into an arrangement in 2004 for Joint Marine Seismic Undertakings, JMSU, a technical term that really refers to oil and gas exploration. And in 2005, the cooperation was extended to include National Oil Company of Vietnam, making it a tripartite joint effort. The JMSU agreement expired in 2008, 3 years later. It did not enter into the next phase of joint exploitation in the defined area as anticipated. The main and the direct cause was the domestic politics of the Philippines. So I'll not expand on this point, since everyone here is supposed to have certain knowledge about it. And some scholars also raised the opinion that the United States also might have some role to play in the outcome of this cooperation. Anyway, the JMSU has now become a part of history, with quite different, even opposing narratives surrounding the story. And the negative comments consider the cooperation as a failed episode. Some even describes it, or the result of the cooperation, as disastrous. My opinion is that it is true that the JMSU did not achieve what had been anticipated from the very beginning. However, it is not fair to describe it as a failure. Essentially, it could be seen as initial progress happened in a long and possibly painstaking process. And it did leave positive marks in such a process. Number one, it demonstrates that something could be done technically and commercially. Number two, although JMSU has got a negative image in the domestic environment of the Philippines, the deal does not lose its value and validity in international relations. It still constitutes a worthwhile experiment for both countries and the South China Sea region at large. Number three, it could be seen that during 2005 to 2008, when the JMSU was in force, no major incidents happened in the South China Sea, at least between China and the Philippines. Situation in the South China Sea got a downward spiral only after 2008. So I will not list all the incidents from then until 2016. And they're quite familiar to the people in this meeting. And China and the Philippines, now after 2016, the situation came back to a relatively calm state. This time, again, partly due to the domestic change of the Philippines. And the two countries resumed bilateral dialogues and successfully managed the sporadic incidents happened at the sea, preventing them from escalating into major confrontation or conflicts. And the two countries, as mentioned by the previous speakers, also signed the Memorandum of Understanding on Cooperation on Oil and Gas Development in Manila in November 2018, which is one of the most remarkable legacies left by the interactions between China and the Philippines during Duterte administration. So you could see that 10 years later, from 2008 to 2018, China and the Philippines had to come back to what had been started, even with a minor step forward, this time by signing an intergovernmental MOU and establishing official mechanisms to oversee its implementation. So the lesson is that seeking oil and gas joint development is a long process with twists and turns. But as long as the two sides took one step backwards and then two steps forward, things are going in a positive direction. The two countries could not afford to step in backwards all the time, for by such a scenario, they would move toward an unpredictable, unintended, and possibly irreversible direction. So as one of the backgrounds of our discussion today, we noticed that, as mentioned by Captain Andy earlier, former Foreign Secretary Lawton's remarks last month maybe cast some uncertainties over the prospect of the MOU. However, we could see some opposing trend also inside the Philippines. Senator Robin Hood Padilla only 2 days ago filed a resolution urging President Marcos to resume bilateral talks for oil and gas cooperation with China in the South China Sea. So we can see that the dust has not been settled yet. So that brings me to my third point, looking ahead or looking into the future. The process of seeking oil and gas joint development is expected to go on, even possibly not by a straight line, but it has to go on. And it is reasonable to forecast that China-Philippine relationship during the term of Marcos will remain stable and even take an upward trend, and which provides a favorable element for the cooperation. However, there are many obstacles as well. Compared with in 2008 and even with 2016, the overall strategic environment has gone increasingly hostile, with the US-China strategic rivalry becoming maybe a fact of life, particularly in this region. And the South China Sea is a major arena for this rivalry. And also the domestic politics, the perceived constitutional constraints within the Philippines, and the public opinions from both sides still have their negative influence. Again, there are still very opposing legal positions and legal opinions between the two countries, which would only intensify the objections from the domestic audience or even from third parties in the world. So that how to proceed? My biggest suggestion is never, ever give up the MOU. So reading the delicately phrased text of the MOU, you can find that this document actually reflects or represents the greatest common denominator on oil and gas cooperation that can be identified or achieved by the two sides so far. And this gives the MOU its substantial and everlasting value, even more so than it being an intergovernmental instrument simply. The MOU, by consolidating this set of greatest common denominator and providing a stable and predictable sense of direction, may all the time serve as an anchor for the China-Philippine relationship and their interactions on the South China Sea, whether under Duterte or Marcos or any other Philippine administrations, as long as the South China Sea disputes exist. So sticking to MOU is not a matter of inheritance, but a matter of adherence, adherence to a process which could only go ahead, although there might be ups and downs. So it is suggested that China and the Philippines could make some recommitment to the MOU at a high political level to sustain the momentum, to sustain the political will, as mentioned earlier by Anna, to demonstrate, sustain that political will, even in recognition that the final outcome might still take time. But the momentum, the direction is very important. And another suggestion of mine is change mindset and keep working. What are those mindsets that need to be changed? For example, maybe we should recognize that oil and gas joint development is only a transitional arrangement, not the end game. Take it as a common problem confronting both sides, rather than a life and death race between the two countries, and solve the problem together, collectively. Another example for the mindset changing is that rest assured that claims and legal positions of both sides will not be affected by this transitional arrangement before any final solutions come about. There is abundant international practice from which the two countries could learn lessons, as Judge Gao pointed out earlier, and let diplomats and lawyers to figure out how to formulate the text in order to be double sure. And also professional experts could also make their contribution and inputs. So long as this arrangement is acceptable to both sides, with the disclaimer clause mentioned above well in place, the arrangements would be consistent with international law, including the provisions of UNCLOS mentioned earlier. And another mindset that is necessary is that we could use the favorable momentum created by the collective efforts of China and ASEAN member states in negotiating a code of conduct in the South China Sea region, and try the best to alienate the South China Sea disputes from the current geopolitical strife. And I think this is very important. At the least, oil and gas joint development between China and the Philippines does not constitute a game changer for the strategic landscape. So make it a commercial, technical, a political transitional arrangement, not something that will change the strategic environment. Actually, even the United States itself said it would compete against China. At the same time, will also cooperate with China when necessary. So at any rate, I think gas and oil in the South China Sea is a case which is necessary for China and the Philippines to cooperate. So with that, I will conclude my presentation. Thank you for your attention.
Thank you, Dr. Yang Li. I like your style of presentation in a retrospective and a prospective logic. And also, you mentioned one interesting point that is often neglected by ordinary people. That is, we should not mistake sovereign rights with sovereignty. And also, given your own experience as a diplomat and your involvement in the previous discussions, I would like to echo the credibility you gave to the previous talks and accomplishments, and also very important and very impressive that all your concrete suggestions we have taken down, and I hope that those kind of message could pass on to policymakers as a kind of a policy recommendation. Thank you very much. Anna, I would like to turn over the floor to you and welcome you to make some comments. Anna, please.
Yes. Thank you, Captain Andy, and thank you so much for that presentation. I think my takeaway is that never give up. We should never give up in trying, to make something out of the oil and gas joint development cooperation between the two countries, China and the Philippines. And I think the process may be tedious. Probably there's so many ups and downs, but at the end of the day, I think every step of the way is a success that we can consider. And I hope both countries will realize this, that, we are destined because geographically we're really neighbors. So that the best thing forward is, as much as possible, is to join, to be together and establish joint cooperation in every possible way, especially when you talk about maritime resources. To introduce our fourth speaker, before that, let me encourage our viewers and participants of this webinar to please feel free to write your question in the chat box. Later, we will try to accommodate them and let our excellent panel of speakers to respond to your question. So now to introduce our fourth speaker, our fourth speaker is Dr. Melissa Loha. She is a senior research fellow of the Integrated Development Studies Institute, and also she serves as consultant on international law and international energy law in various agencies. She is the vice chair and lecturer in the International Law and Maritime Law Department of the Philippine Judicial Academy. Ladies and gentlemen, let us welcome Dr. Melissa. Dr. Melissa, please proceed. Thank you very much.
I can't see my screen for some reason. One moment, please. Sorry.
Yeah, it's okay. It's okay, po. But we can see your PowerPoint on the screen.
Right. Well, what do I click to restore the screen? Something. All right. I'll just. Okay.
Okay.
Right. Thank you for the kind introduction. Good afternoon, everyone, especially for the panelists from China, I feel that this is some form of simulation. So let me give my three main points for this presentation. The first main point is that the conditions, are you able to see the screen moving? I'm on my second screen.
Not yet, Dr. Melissa. I think it's not moving to the second screen. We are still seeing the first slide.
Okay. There. Are you able to see it now?
Not yet, not yet, not yet. I think we should, is it possible for you to put it in a presentations screen?
Actually, my trouble is I can't even see the screen for Viber. I don't know which thing to click. Should share. Are you able to see it now?
Only the first page.
Yes, but so if I move it, are you able to see the second
Yeah.
page?
Okay.
Yeah. Yes.
Right.
Second slide already.
Right.
Yeah. Okay.
So the first main point that I wish to make is that the current condition, domestic condition in the Philippines, is not conducive to joint development. It is slightly conducive to joint exploration, but I would qualify. It is slightly conducive to purely commercial cooperation onshore. It is not so conducive to purely commercial cooperation offshore. And I shall elaborate later. The second main point I wish to make is that the MOU is not lost. It can be salvaged. And the final point that I shall make is that we have to move on from joint development. We have to end our obsession with the concept and theory of joint development and rethink some expanded form of cooperation in the South China Sea. And I shall explain why I say this. So in response to the questions raised by the organizers, let me present my response in three parts. The first part is on the current state of the environment for cooperation. The second is on the status of the MOU. Are you able to see me? And are you able to see the second part? Hello?
Yes.
Right. And the final part would be on the lessons that we can use moving forward. So on the current state of cooperation, let me examine three forms of cooperation based on our experience. I'm on the third slide. Are you able to see it?
I think you need to click the third slide so we can see it.
I have actually clicked the third slide, but
Yes. Current status, I think.
yes.
Yeah.
All right. Okay. So the current status of cooperation in the Philippines can be examined based on three experiences. The first one is on the Joint Marine Seismic Undertaking. Now, this was an agreement among the national oil corporations. This was not an intergovernmental agreement, although later on, the agreement was formalized by President Arroyo and the ambassador from China and the ambassador from Vietnam. Now, under this agreement, the two national oil corporations will engage in a survey of an area, which in my presentation is shown by the broken brown lines, in an area which consists of the EEZ and continental shelf of the Philippines. Second, the territorial sea of rocks occupied by China and Vietnam and claimed by the Philippines, and the territorial sea of rocks occupied by the Philippines and claimed by China and Vietnam. Now, the opposition from the part of the Philippines to the JMSU, or by some groups in the Philippines, was that the GMSU, number one, covered mostly areas that are being that are claimed or that belong to the Philippines. Of course, it's a claim, but of course, that was the basis of their opposition. And also because there is a provision in the Constitution of the Philippines which provides that when it comes to resources, including resources in the EZ and the continental shelf, the utilization of these mineral resources will have to be exclusively for Filipinos. So that was the basis of the opposition to the Joint Marine Seismic Undertaking. Now, based on that experience, one can say that there's almost zero possibility of a joint exploration. But I will explain why that is not the case, that there is a chance for some form of joint exploration. Now, the second experience we had was the MOU in 2018. Now, the termination of this, the speech of Secretary Locsin is not really clear on whether there was a termination of the MOU, the termination of the formal negotiations under the MOU, or the termination of the informal negotiations under the MOU. The speech merely says that the objective of the Philippines was for oil and gas cooperation, and that there was going to be a termination of negotiations that was undertaken for the period of 3 years, and that the termination is final, and because the reason for the termination are constitutional obstacles. So that was the presentation of Secretary Locsin, and I will discuss why there is still a chance to salvage the MOU even with the speech of Secretary Locsin. I will do so in the second part. But finally, I consider as a signal or an indicator of the receptivity of the domestic audience to cooperation with China, any purely commercial licensing cooperation taking place between a Chinese International Petroleum Corporation and the Philippine government. And here there is an indication of receptivity when it comes to a productive service contract. And this is in onshore service contract 40 in Alegria, Cebu. But there's also another ongoing service contract, that is service contract 70 under Polyart, and that is a Hong Kong-based International Petroleum Corporation. And to those two petroleum corporations, there is an ambivalence, not really in the sense that the domestic audience supports the two corporations and their undertaking, but more or less a lack of resistance to that form of undertaking. In contrast, when it comes to offshore, there is a resistance even to a Filipino corporation such as Udena assuming operatorship or taking participation in service contract 38 under the suspicion that Udena is actually a Chinese interest corporation. And that resistance is indicative of what could happen if there is some form of cooperation between China and the Philippines offshore. And we have to remember that service contract 38 is not even disputed, although service contract 38 straddles the 9-dash lines. China has never claimed service contract 38 as its own, or has never stopped any oil and gas activities in service contract 38. And yet the resistance, the strident resistance to Udena is borne out by suspicions of Udena being actually a Chinese investment or harboring Chinese investment interests. So based on these three factors, one can say that there are contradictory aspects in the existing condition for cooperation between China and the Philippines in oil and gas. And the first one, of course, is that when it comes to joint development, there will be resistance based on the interpretation of the arbitral award that there is no overlap between the Philippines and China, especially when it comes to the EEZ and the continental shelf. Even the definition of Professor Gao would support the view that joint development presupposes the existence of an EEZ-CS overlap. Very rarely is there a joint development in an overlap involving territorial claims. It's mostly maritime claims in the EEZ and the CS. The possible example of a territorial claims having a joint development is the one in the Persian Gulf or in the Middle East. But nonetheless, in the Philippines, there will be resistance to any form of joint development. And by that, I mean the classical form of joint development, where there is a defined area in an overlapping zone involving two opposite or littoral states. And the overlap is between CS and EEZ, but not CS, EEZ, and TS. There has never been a joint development between two different categories of maritime zones. And that joint development being one where there will be sharing or almost equal sharing of ownership and operational authority, as well as almost equal apportionment of proceeds. No. So based on what I explained, there will be resistance to such an idea. With respect to joint exploration, I think there will be also resistance if the joint exploration area is as extensive as the JMSU area, where there are more Philippine EEZ and CS is covered by the area and less coming from the part of Vietnam and China. Although it has been lost to most commentators about the JMSU, that what is covered by the area of the JMSU is not just the EEZ and CS of the Philippines, but no less than the territorial sea of the rocks that is found, that are being occupied and claimed by Vietnam, China, and the Philippines. So also there has to be some consideration of the participation of Vietnam in any form of joint development or joint exploration if we are to have a stable environment in the South China Sea. But let me point out that in 2014, the ambassador of Vietnam, from Vietnam, proposed to the Philippines some form of joint exploration. But I looked into the reaction from politicians and from commentators in the Philippines and found no comment at all, no resistance, no objection, as though there would be no problem if Vietnam would raise the idea of joint exploration with the Philippines. But since 2014, there has been no concrete steps towards that direction. So I'm not sure if that has progressed at all. Now, of course, when it comes to purely commercial cooperation, as I mentioned, there is domestic resistance and as well as ambivalence, depending on where the commercial undertaking of a Chinese investment corporation is taking place, whether it's onshore or offshore, and whether that particular undertaking is visibly productive. So based on these contradictory aspects of cooperation, I might summarize and conclude that at the present, the environment is shaped very much by geopolitics. And it is rationalized by a particular legal narrative that has not been challenged formally or even in a widespread manner by any other commentator from both the geopolitical as well as the international law fields. But given the contradictions open the door for correction, the environment can also be reshaped. And it can be reshaped through economic pragmatism rather than geopolitics. And that economic pragmatism might become the dominant factor as the Philippines faces an energy crisis brought about by the current global events. Now, in order for a commercial undertaking by, oh, sorry, I have moved. Sorry. In order for a commercial undertaking by China to be that needs to be received well by the Philippines, whether it's onshore or offshore, maybe there is a need for that particular undertaking to be visibly productive. And in that way, the environment might improve for purposes of engaging in cooperation. But when it comes to joint exploration and development, there would be some resistance in terms of narrative based on what is shown on the screen as Section 2, Article 12 of the Philippine Constitution, which expressly says that mineral resources will have to be utilized exclusively by Filipino citizens. However, the same provision contains an exception to the general rule. And that exception states that the president may enter into a financial, which are high risk investment contracts, financial or technical agreement with a wholly owned foreign corporation for purposes of mineral extraction, oil and gas extraction included. And this particular exception has been interpreted by the Supreme Court to mean that service contract, petroleum service contracts, onshore or offshore, may be issued in favor of a foreign corporation, and that therefore oil and gas resources are exempt from the general rule under Article 12, Section 2. And the only conditions imposed by the Supreme Court is that, number one, there has to be a law existing authorizing such licensing to a foreign corporation, such as a Chinese corporation, offshore or onshore. And that second, there has to be an agreement or adoption of the agreement by the president himself or herself. And in this case, the onshore contracts of China meet all the requirements, and at the same time, the offshore contracts will have to meet those requirements. The objection of exclusive utilization by Filipinos is a legal narrative that can be modified, especially if the Philippine Supreme Court decides on the existing petition on the constitutionality of the joint marine seismic undertaking. And I think that most commentators and most interest groups have completely ignored that the Supreme Court is a battleground for narratives about the South China Sea. And in any event, of course, as I said, joint development is conceptually problematic for the Philippines, especially in the light of the arbitral award. Now, we can say, of course, that the arbitral award can be set aside, but to do so would be to modify the status quo ante, that is, the status quo before the 2018 MOU. Remember that our starting point is the 2018 MOU, and at that point, there was already an arbitral award. And if the Philippines will have to abandon the award in order to proceed with the negotiations, then it would, in fact, be accepting a very different status quo, which is not favorable to Philippine interests. Now, what then is the state of the MOU? Is the MOU the way forward for the Philippines and China in terms of negotiations? Now, when Secretary Locsin canceled made a speech about the termination of negotiations, it was not clear exactly what Secretary Locsin was referring to. And therefore, let me examine the implications for whether Secretary Locsin was terminating the MOU, the formal negotiations, or the other types of negotiations. And let me go to first the remarks of the Secretary, and let me break it down into the following. First, the Secretary mentioned the termination of a 3-year negotiations. Okay. Second, he said that the obstacle to further negotiations is constitutional. on the part of the Philippines. And that as a result of the termination of the 3-year negotiations, there is now a failure on the part of the Philippines to adopt a form of arrangement that would allow for development of oil and gas resources. So that is the context of the speech. Now, I have not seen any official statement or communication for the termination of the MOU. But in any event, let us assume that the Secretary was referring to the MOU. Let me begin by registering a contrary view to that of Professor Gao when he said that the MOU is an international instrument. For me, the MOU is not a substantive agreement. It is not at all a treaty. And this is so based on an express provision of the MOU itself, and that's Section 4, which says that it will not generate rights and obligations under international law or domestic law. And we know that an international instrument is precisely that, a source of rights and obligations. And if the MOU is not a source of rights and obligations, then it is not a treaty. Okay? Now, what is it then? It is a mere agreement to agree. And there are various aspects that were agreed upon by the two parties. First, it was an agreement as to the output of negotiations. And here it is important to point out that what was agreed upon as a possible output is a form of arrangement to facilitate oil and gas exploration and exploitation. Here, there is no mention of joint development. It can be any form of arrangement, and we have to be creative as to the form of arrangement that we can negotiate on and eventually adopt. And it will be an arrangement on oil and gas exploration and exploitation in a relevant maritime area. There is no definition of the cooperation area. And finally, it will have to be consistent with international law rather than with the domestic laws of the two countries. And of course, by international law, here we mean some form of a bilateral agreement or maybe even a functional agreement between the two parties that would then be the source of rules and rights and obligations within that cooperation area, whatever that might be. At the same time, it was an agreement to mechanisms, including principles that will govern the behavior of the parties. And therefore, if we say that what was terminated was the MOU, then that would be disastrous. That would bring us back to the Stone Age, because then all of these agreements will have been abandoned. And that for me would be a shame. Nonetheless, if we assume that what was terminated was a formal negotiations, again, I would disagree. Why? Under the MOU, there was an agreement as to the structures for negotiation. First was the Intergovernmental Joint Steering Committee and the Inter-Entrepreneurial Working Group. Now, the first and only meeting of the committee was on October 28, 2019. No other meeting, no other formal negotiation took place thereafter. And I think this is where the two parties failed each other. There should have been a sustained formal negotiation rather than the hijack of the negotiations by private entities. In this situation, there was already a committee. They met in October. They agreed, in fact, and if you look at the minutes of the meeting, they agreed to establish a legal and technical working group that would then propose various forms of cooperation arrangements and even various areas for cooperation. It was the most important step in this negotiation, but unfortunately, for some unknown reason, the legal and technical working group was never established. And I think if we are to restart negotiations under the MOU, the first order of the day should be the immediate constitution of the legal and technical working group. It could be separate legal technical working groups on each part, and for them to come up with a working negotiating text within 30 days, if possible. That's just my view. And anyway, and of course, the other structure would be the entrepreneurial working group. Now, this group, the entrepreneurial working group, was not constituted at all, because the existence of this group depends on the agreement that will be forged by the committee. As no negotiation took place at the committee level, no agreement was achieved or adopted at the committee level, there was therefore no entrepreneurial working group to speak of. So if one would say that the formal negotiations were terminated by Secretary Locsin, I very much doubt that that is the case, because there was no formal negotiation at all. Instead, there was some form of direct but informal yet full negotiations between Forum, PXP, and the Ministry of Foreign Affairs and China National Offshore Oil Corporation. In all these negotiations, there was no Philippine government representative present. And there were the talks about the cooperation area, the modalities of cooperation, as well as the allocation of costs and proceeds. Now, this took place over a period of roughly 3 years. And I would say that this was the negotiations that Secretary Locsin announced to have been terminated, rather than the MOU or the formal structures for negotiations under the MOU. And I think that Secretary Locsin was justified in terminating this type of negotiations, as I will explain later. So in response to the second question of the organizer, yes, there was a termination, but the termination referred to the other negotiations rather than to the MOU itself or the formal negotiations at the committee level. And I would say that the termination of that type of negotiation was justified, as there were a number of problems raised by Secretary Cusi regarding the authority of the private entities, the scope of their negotiations, the area for negotiation, as well as the terms of negotiation. Remember, as I said, the MOU did not create rights and obligations, and that includes the capacity to amend Philippine laws. And under Philippine laws, especially Presidential Decree 87, it is only the DOE that can engage in any form of negotiation regarding areas for oil and gas, as well as the commercial terms for oil and gas. There would be need for an amendment of PD 87 before that can happen. So the MOU is not a law that can amend Presidential Decree 87. So structurally, it was already very problematic. So moving forward then, what lessons can be learned given the conditions, the structural contradictions for joint development? As I pointed out, we have to argue that there is an overlap, where even if there is no such overlap under the arbitral award as the Philippines have adopted. And also we have to examine the status of the features that will be covered within the cooperation area, especially as these features are territories and they are occupied by Vietnam and China, as well as the Philippines, and they are claimed by these three countries as territory, including the territorial seas generated from these rocks. Now, also, because of these structural contradictions, every negotiation on joint development on oil and gas cooperation that focuses on joint development ends up in a binary between joint development or farm-in, ownership of resources in situ or at the wellhead, or non-ownership, as well as problems about operational taxation and other legal jurisdictions. So my view is that we have to be creative and look outside. Think outside of the box. And for me, these are just my views. We need to step back and look at the whole, the entirety, the range of relations between the Philippines and China. And we, as far as I'm concerned, I think that the underlying interest of China is not at all economic gain. It is not after oil and gas resources per se. I think the primordial interest of China, especially in the current situation, is for maritime security and a buffer zone in the South China Sea. I think this is a provocative statement coming from me. I am not a geopolitical expert, but I think if we just go down into the basics, I think that is the red line as far as China is concerned. Now, for the Philippines, the red line is loss of sovereign rights, or maybe loss of sovereignty, of course, when it comes to the rocks. But the interest that we hold when it comes to negotiations for oil and gas is simply energy and food security. And therefore, also, of course, we need to consider the interests of the international community, and which is freedom of navigation in the South China Sea. It cannot be avoided. The South China Sea has been the site of freedom of navigation for years. And therefore, the only possible avenue for cooperation is not one solely for oil and gas, and not one focused on joint development. I think we need to adopt, and I think we need to consider already, a 4-layered multi-purpose zone, which takes into account the safety and security interests of the parties, the fisheries interests of the parties, as well as oil and gas, and of course, maritime trade by the international community. And I say this because at the end of the day, we need for everybody to come to bring home something. And for the Philippines, we have to bring home energy and food security without losing any particle of sovereignty. And for China, I think, given the distance of the area from the coast of China, and given its existential interest in the South China Sea, I think that your interest would be served if we are to design a safety or security buffer zone agreement of some form. I'm not suggesting any specific one. Under international law, each platform is entitled to only a 500-meter safety zone, but I don't know what can possibly be adopted as a security arrangement or a safety arrangement. I'm not sure. That is something for the experts to negotiate on and to think about. And of course, for this reason, there is need for us to expand. There is need for us to expand. Okay. There is need for us to expand the legal technical working group to something like a legal technical security fisheries working group. So it will have to be a very functional negotiation rather than one that is normative. And finally, if we look at the best practices around the world, we can just imagine the range of cooperation that has been undertaken when it comes to oil and gas, and the methods that have been adopted. And let me just mention, for instance, the maritime boundary agreement between Netherlands and Venezuela, where there is a provision that triggers a resource clause, that if they find a resource that straddles the boundary, then automatically there will be a negotiation, a consultation and negotiation for how to deal with a shared resource. The other form is a more detailed resource clause, such as between Equatorial Guinea and Nigeria, because that particular clause compared to the one between Netherlands and Venezuela. That particular clause already details who has authority to negotiate, what will be the form of negotiation, will it be unitization, will the definition of the area be field specific, meaning should there be first a detection of a field that straddles the boundary, or could it just be a joint development area where there is no field that is established yet? Of course, there is also the joint development agreement between Japan and South Korea, which already delineates a zone and leaves everything else to further negotiation. And another form of joint development agreement between Malaysia and Thailand, where they only created a legal entity, a third legal entity that will then adopt certain provisions for purposes of carrying out the joint development. And for me, the more important, the more relevant agreement, is that between, I can't even see. All right. For me, the more relevant and the easiest to adopt is a form of agreement between the national oil corporations of two countries, or even just the petroleum agencies of two countries. And here I refer you to China and Vietnam, both of which have a joint exploration agreement dating back to 2013. And that agreement was amended in 2015. And the zone for exploration was expanded to go beyond the limitation line in the Gulf of Tonkin. And there's also, of course, a joint JD and unitization agreement that can be found in the contracts, existing petroleum service contracts of the two countries, such as the one of Vietnam, where there is a provision that says that if a field is suspected to straddle a boundary, then there is an automatic, then a process is triggered where there is a negotiation taking place between national oil corporations. Thank you very much. Sorry for the technical difficulties.
Thank you very much, Dr. Melissa. I think for that very straightforward, really thought-provoking presentation. I think for me, my takeaway, and also there are so many things that I've learned from your presentation. But I think one thing that is important is the clarification about the MOU, that, it was canceled, but, you've explained it very well. And on the other hand, that there's such a thing as, that we can salvage what the MOU, and it's not lost forever as what other people have perceived because of that speech or interview with former Secretary Locsin. And also, I think it's very good as well that you've addressed the limitations of the constitution of the country, of the Philippines, vis-a-vis any kind of joint oil and exploration or joint gas and oil exploration in anything that is considered to be part of the Philippine territory, or we have a so-called sovereign rights. But you've explained it that there are, we need to be creative about all these things, that we need to think out of the box for us to be able to push forward what is good for both country. And one thing that I also like in your presentation, I think, is to look at the whole problem or the whole situation from a macro perspective and consider everything. And one thing that I agree with you is, yes, the geopolitics is also one of the most important consideration in the discussion of all these things. If we really want to address the issue holistically speaking. So may I thank you very much, and it was really candid presentation, and I like it. I actually like it. On the other hand, let me turn the floor to Captain Andy for the introduction of our fifth speaker, second to the last. Thank you very much.
Thank you, Anna. The fifth speaker from the Chinese side is Mr. Tingting Luo, Associate Research Fellow of National Marine Data and Information Service. Ms. Tingting Luo, please, the floor is yours.
Okay, thank you. Thank you, Captain Andy, and good afternoon, ladies and gentlemen. I'm Tingting Luo from National Marine Data and Information Service. It's my great honor to discuss the issues here with all the experts. Today, my presentation will focus on the significance, obstacles, and wise choices about the oil gas joint development arrangement, JDA between China and the Philippines. Now I'll begin my presentation. As we know, JDA is a provisional arrangement and UNCLOS, and is widely accepted in state practice. Further setting the boundary in areas of overlapping claims may require a very long negotiation, so the UNCLOS caters for the fact that provides a temporary solution to this situation. In paragraph 3 of Article 74 and 83, these solutions include moratoriums on resources exploitation pending final delimitation and an obligation to take every effort to make provisional arrangements and not to jeopardize or hammer the reaching of a final delimitation in the interim. But as we know, the UNCLOS does not mandate the type of provisional arrangements states can enter into, so it leaves it to the discretion of the states concerned. But there is no doubt that JDAs are one of the provisional arrangements. Indeed, it appears to be the most commonly used arrangements for overlapping claim areas. As the judicial decisions, the international courts and the tribunals have also endorsed joint development agreements as an alternative to maritime delimitation. For example, in the North Sea continental shelf cases, and the Tunisia and the Libya case, and the Eritrea, Yemen arbitration, etc. In the North Sea continental shelf case, the ICJ holds that joint exploration agreements were particularly appropriate when it is a question of preserving the unity of deposit in areas of overlapping claims. For state practice, as we know, there are many precedents setting for the JDAs. For example, the Japanese-South Korea arrangement was the first offshore oil development in East Asia. The Timor Gap arrangement, by far, is the most detailed one, and it still remains a good model for joint development in the world. The Malaysia-Thailand and Malaysia-Vietnam joint developments are successful models in the South China Sea. So, in conclusion, cooperation to management and exploit shared marine resources may be a better solution for setting overlapping maritime claims than waiting for an agreement to reach after a long negotiation progress. Now, I will come to the significance of Sino-Philippines JDA and some consensus achieved by both sides. As we know, the South China Sea has sometimes been labeled as the new Persian Gulf. The increasing demand for energy that China and the Philippines are facing can be viewed as the most important economic incentive to jointly exploit oil and gas resources. Both countries need a good environment for social and economic development. The obligation of good faith in the context of South China Sea means we are willing to negotiate maritime boundaries or joint development zone with an open mind. As we know, JDA can create a good atmosphere for resolving Sino-Philippine maritime dispute peacefully, also enhance and expand bilateral cooperation. There are two conditions necessary before there can be serious discussion on joint development arrangements. First, joint development agreements tend to be concluded in periods where good relations existed among the relevant parties. Second, the parties must have the political will to make decisions that may face oppositions within their countries. Now, we'll see some obstacles between the two countries. There are so many factors that involving with the JDAs. As we know, the political will, the domestic public opinion, and the recognition of overlapping claims and the external interference. As we know, negotiating joint development agreements are very complex. So it requires considerable expertise and commitment of time and resources. A high level of political will within each state is necessary to achieve this progress. And the domestic political opinion is very important too. It's an important fact that both sides should consider. As we know, in Philippines, many people are concerned that the JDA is a breach of the 1987 Constitution of the Republic of the Philippines, because the Article 20, Section 2, as follows: all lands of the public domain, waters, minerals, coal, etc., and other national resources are owned by the state. Exploration, development, and the utilization of natural resources shall be under the full control and supervision of the state. So some Philippine people will think that is really a breach of the Constitution. The external interference is also a big obstacle for the development. The US have put forward some reports concerning the settlement of oil, island, and the fishery dispute in South China Sea. It wants to set restriction of China's power imposed by the mechanism of joint development. I have read some essays, and I have seen that some scholars from the ASEAN countries even said that. They say the Chinese proposal has the intention of enhancing de jure access to dispute areas while it maintains de facto control of the area. So, what should we do next? In my opinion, there are some wise choices. We have to confront the obstacles, and we should choose what we should do. For both sides, it's very useful. It's meaningful to both countries. First, as we know, the MOU between China and the Philippines have been signed in 2018. The consensus achieved by both sides should be respected. Both sides should have a certain level of trust in each other. Pending the dispute and finalizing the without prejudice provision is very important. As we know, the without prejudice provision, it ensures that whatever arrangement agreed to will not affect the final boundary agreement. A JDA gives the states the opportunity to exploit the resources without giving up their claims to sovereignty or sovereign rights in the joint development area. So, agreeing to a joint development area, in fact, means sharing the dispute for a generation or two, while enabling both sides to benefit from the exploration of the hydrocarbon resources in the agreed area. In fact, China has been devoted to promote good faith in the South China Sea in recent years. China has reaffirmed with the Philippines that it will address territorial and jurisdiction disputes by peaceful means, increasing mutual trust and confidence, and to exercise self-restraint. China high-level diplomats have also demonstrated goodwill to the ASEAN claimants in recent years. For example, Cui Tiankai, former Chinese ambassador to the US, said that China is not trying to take back the islands and reefs that are illegally occupied by others. That's the remarks at the Center of Strategies and International Studies in 2016. Chinese government has also educated the public on the benefits and the importance of joint development and emphasized the fact that it does not involve a surrender of sovereignty. So I think it's very necessary for both governments to report the concerning issues to citizens and gain their support. Chinese mainstream media have paid close attention to the conception of pursuing joint development while shelving disputes since 2017. Chinese government has made great efforts to manage domestic politics and tone down the nationalistic rhetoric associated with the South China Sea dispute. So, successful negotiations for COC may help to create a conducive atmosphere for the joint development in the South China Sea. We have to build our strong trust between each other. In order to lower the difficulty of the negotiation, I think we should set a transitional period to reduce the obstacles and try to deal with substantive and technical issues first. I have seen that someone have left the questions online. Is there a time limit for the MOU? The answer is there is no. There's no limit, time limit. So it leaves more time for us to deal with the obstacles. So we can have enough time to reduce the obstacles. The last one is that written agreements provide a legal basis for the scope of joint activities under consideration, are certainly preferable to the ambiguous arrangement. So the precise terms of an arrangement may provide limitations on joint activities and protect a state against less forcible consequences and the factual changes that might occur. So I think that an important strategy to protect states against unforeseen or long-term consequence would be to include provisions on the duration and unilateral termination of an arrangement. There is something I want to say that China has, there are plenty of work that China and the Philippines can do. For example, China needs to provide more public goods such as navigation safety, environment protection, maritime salvage, and weather forecast. That's my presentation. Thank you.
Thank you, Dr. Tian, for giving awareness to the importance of international practice and jurisdictions and regarding the joint development areas. You also, I think, I can also recall the previous speakers, Dr. Melissa, both, I think at least 3 speakers have mentioned the constitutional strengths on this issue. I'm not a constitutional expert, but I would like to ask a question for maybe further deliberation after the meeting. As Dr. Melissa also mentioned, there are seldom GDA, joint development practice regarding the overlapping territorial areas. And also, I also saw the response, her response to one question. If there is no overlapping areas, there will be very difficult for joint development. My question is, if whatever kind of agreement is reached by both governments, I think it is a kind of exercise of sovereignty, not giving up sovereignty. take the status of forces agreements, for example. Normally speaking, foreign armed forces is not allowed to station in one sovereignty state, but by signing the status of forces agreements, one country, by exercising the sovereignty, can take the foreign armed forces in their territory. So this is one of my question for further discussion. So without further delay, I'd like to turn over the floor back to Anna. Anna, please.
Yes, thank you, Captain Andy. Yes, I think we can ask question later. So to introduce our last but not the least speaker, he is Professor Celso L. Cainglet, a senior lecturer at the University of the Philippines in the Visayas. His career and professional life may be described as largely academic in nature, serving as a faculty member in various university colleges and institutes in the country to the present day. Professor Cainglet is one of the awardees of the Award for Promotion of Philippine-China Understanding this year, 2022. Ladies and gentlemen, join me in welcoming our last speaker, Professor Celso Cainglet. Professor Celso, the floor is yours.
Thank you very much, Anna. Thank you very much, Captain Andy. And most of all, thank you very much to our distinguished speakers. I learned a lot from you, and many of you confirmed my position this afternoon. I will take a slightly different path because I know that the question posted earlier will be tackled already. It's already 2022, and I cannot believe we're still discussing about boundaries. These territories, these national territories, are 18th century construct. In a globalized world, they are being eased out already. What I'll do, I'll attempt to elucidate on the complex Philippine political milieu and how it hinders development and impedes the country's participation in the rising economy in Asia. Dr. Yang Li, Dr. Ting Ting already mentioned about the importance of the local political dynamics, and I will more focus on that so that we will have a better appreciation of what really happened, why this conflict escalated. Because I believe that the laws, the technicalities, they're very flexible. If there's a will, there's a way. In fact, even UNCLOS states that if there is an overlapping dispute, they leave it to the two countries to settle the matter themselves. Okay, so UNCLOS is flexible when it comes to territorial dispute, leaving most of the solutions to the countries in dispute to settle the matter diplomatically. However, due to the patronage politics and hegemony of the oligarchs in the Philippines, settling disputes have become more complicated due to the vested interests of particular groups. Personally, I don't see any major problems in the technicalities of the joint gas and oil development cooperation between China and the Philippines. More so, I don't see any problem on the side of China. The problem I see is on the side of the Philippines. The problem is more on the social political factors that beleaguer Philippine society. This will be illustrated by briefly narrating the recent historical events, particularly during the presidency of Benigno S. Aquino, that led to the escalation of the conflict between the Philippines and China. The previous administrations prior to Aquino did not have any major discord with China. There were slight irritants during the presidency of Fidel V. Ramos due to his alliance with the United States. Ramos would once in a while toe the line of U.S. interference in the Indo-Pacific region. The height of Philippine-China stable diplomatic relation happened during the presidency of Gloria Macapagal Arroyo, and only to plummet during the presidency of Aquino. I would like to acknowledge Bobby Tiglao, a local journalist and former press secretary of the Office of the President, who did most of the extensive research on the historical events that led to the escalation of Philippine-China territorial dispute. So what really happened? There are three groups interested in the hydrocarbon deposits at Reed Bank. The First Pacific Company, owned by the Indonesian Anthony Salim, who also owns a vast majority share in Felix Mining, a subsidiary of PXP Energy, formerly Felix Petroleum Corporation, which owns Forum Energy. Salim's man in the Philippines is Manuel Pangilinan, who owns several multi-layered companies in the Philippines. Salim's partner in the Reed Bank project is the casino magnate Enrique Razon. Third, Roberto Ongpin was 20% of Forum Energy. It was Ongpin who led the investors group in 2008 to sell the last tranche of Felix Mining to First Pacific. On February 10, 2009, the Energy Department issues to Forum Energy, the firm of Salim conglomerate known as the First Pacific Group, service contract number 72 to extract gas and oil in the Reed Bank. In a note verbal, China protested the issuance of Service Contract 72. A similar protest was issued on May 13 when Benigno Aquino III became president in 2010. He appointed Salim conglomerate executive Albert Del Rosario as Foreign Affairs Secretary. On February 30, 2011, Forum Energy dispatched seismic survey vessel MV Veritas Voyager to the Reed Bank in the Spratlys. On March 2, 2011, China's civilian CMS vessel, China Marine Surveillance Vessel, blocked Forum's vessel, saying it did not have the authority to explore for gas and oil in the area. On July 25, 2011, Aquino, in his second State of the Nation address, ranted against China for blocking the Forum Energy vessel. He claimed what is ours, and announced his plan to file a case in the International Tribunal for the Laws of the Sea. On the side, when Rosalind Higgins, the first woman president of the International Court of Justice, already declared that nobody owns those hydrocarbon deposits because they're transcontinental transboundary movement under the continental shelf. No? It's only when you capture it that the law of capture applies. The Philippines does not even have the law of capture. The model for these are the Nordic countries. No? According to Bobby Tiglao, what triggered the tension between the two countries was China's driving away from the Reed Bank on March 2, 2011 of an oligarchic trio vessel, MV Veritas Voyager. Aquino was implacably livid about the incident as if he has a personal stake at it. The Aquino regime concealed the involvement of that private consortium in the Reed Bank incident. It lied to Filipinos, saying it was Scarborough Shoal standoff from April to June 2012 and the resultant loss of the shoal that triggered its filing of arbitration case against China. The original plan was to file a complaint at the International Tribunal for the Laws of the Sea, but was cancelled upon the advice of the international law firm Foley Home, for it involved sovereignty claim and will be surely tossed out by ITLOS, for it cannot be resolved by UNCLOS or court. The law firm instead advised that it be packaged as an arbitration case on maritime entitlements and not on sovereign disputes. During the height of the tension, China was willing to discuss diplomatically with the Philippines in a bilateral dialogue. But the Philippines, upon the advice of Foreign Affairs Secretary Albert Rosario, who follows his American masters and his boss Anthony Salim, insisted on a multilateral talk involving the United States of America. China refused a multilateral discussion. Why did America wanted to join in a fray? As Asians, when there is conflict with our neighbor, as much as possible, we avoid going to court. We settle it among ourselves, or we call uncle to mediate on the settlement. The Aquino administration brought the matter to the Permanent Court of Arbitration at The Hague. China did not participate in the arbitration, so technically there was no arbitration that took place. The arbitration panel ruled in favor of the Philippines, expectedly since the PCA is a private company and it was paid with a huge amount of money by the Philippines amounting to 1 billion pesos for the arbitration proceedings, and expectedly will rule in favor of its client. In the first place, I don't think the panel has the capacity to rule or the authority to rule. If you read the decision closely, it does not tell China to do anything. And technically, the PCA cannot make such a ruling. But the Aquino administration, through its mouthpiece, Associate Justice Antonio Carpio, made it appear that the PCA was a United Nations body, and the ruling was a victory for the Philippines. They lied again. The Department of Secretary Affairs hired a Washington-based NGO, the Center for Strategic International Studies, alleged to be a CIA front, to help strategize the countries dealing with China. It was the CSIS who crafted the media operations to demonize China, to make China appear as a bully who grabbed Philippine territory. They launched a well-oiled media machinery, tapping mainstream media outlets and new media outfits such as Rappler, Verifiles, and so on. The National Endowment for Democracy is one of the funders for the operation. They harp on the Filipino Cinderella complex, that is, the feeling of Filipinos as underdogs being bullied by the rich and powerful. Filipinos have already a primordial xenophobia inculcated by the Spanish colonizers. The Spaniards then were threatened by the progress of Chinese traders that they drilled into the minds of Filipinos that the Chinese cannot be trusted. Aquino took the cudgel for the triad's business interests, putting the nation in jeopardy not only in the possibility of war with China, but endangering its economy since China is a major trading partner. Aquino's minions, DFA Secretary Albert De Rosario, who apparently had the interests of his boss Anthony Salim in mind, and then Defense Secretary Voltaire Gasmin, frequently made a trip to Washington begging for American assistance in the South China Sea conflict. The Americans would make great promises, citing the Mutual Defense Treaty of 1951, but at the end of the day, would advise them to settle the matters with China diplomatically. Aquino also went to see Barack Obama, requesting the United States Navy to escort Philippine ships going to the shoal, but Obama said no. Way back in the 60s, the Philippines almost went to war with Malaysia over the Sabah claim, and the Americans categorically denied assistance. During his presidency, Fidel Ramos went to U.S. Ambassador John Negroponte, seeking assistance from the U.S. on the intrusion of Chinese vessels at Spratlys, but was advised to settle the matter with China himself. Aquino's passionate ranting for the sake of the oligarchic triad formed assumption that he may have a stake in one of the companies, and indeed there were allegations that his family had a stake in the project, which would generate billions of dollars from the hydrocarbon deposits at Reed Bank. So local politics, vested interests, not the technicalities, not the Constitution, because in fact, the Constitution can be amended, are, I believe, in my opinion, were the major factors. And Filipinos were deceived. And because usually when discussion on the South China Sea issue were conveyed, they're very, very technical, and the ordinary people could not understand them. That's why Professor Ana and I were just talking 2 days ago that we have to come up with a good communication plan and look for a platform in which we can explain to the people in a very, very simple language what really happened. Because the support of the masses, the support of the people is very important. Take note, our leaders are politicians, and politicians respect numbers. So if there's a pressure from the people, if there's a growing consciousness within the Filipino people what really happened and they were deceived by mainstream media, hopefully all those technicalities will be set aside. Because even our present president, Ferdinand Marcos Jr., when his father, Ferdinand Marcos Sr., went to China in 1975, he talked to Deng Xiaoping. I think at that time, Deng Xiaoping was just vice premier. And he brought up this issue on the dispute, on the territorial dispute. And Deng Xiaoping told him, let us set that aside. Let's do business. Let's leave that to the future generation. Maybe the future generation will have more wisdom to deal with the issue. And personally, I believe maybe in the future, these boundaries, these territories in a globalized world will be eased out. Thank you very much.
Thank you very much, Professor Celso Cainglet, for that. I think for me, as Professor Celso explained more the domestic, domestic issues, more political issues, no? While there is this kind of, how would I call it? Well, it contributes to the obstacle, I think, of forging, no? Good relation with China in a way, especially when you talk about a very sensitive issue like the South China Sea, precisely because there are also local and domestic politics that are coming into the picture, and I think that's what Professor Celso is trying to share with us, no? So this is more on localized perspective. Yeah, and I thank you for that, Professor Celso. At least in this webinar, we have different perspective, no? Coming from historical perspective, coming from a legal point of view, and also from a political and socio-political point of view, which would give us more a macro and micro view of the whole gamut of issues that surrounds the South China Sea, and more particularly the concern as to the joint oil gas development cooperation between the Philippines and China. So that I think this webinar is successful in that sense. Captain Andy, we'll move to the second part of the webinar, but you know we are pressed for time. It's already 5:28. I think both in Beijing and also here in the Philippines. So probably we should just have one question addressed to everyone, to all our speakers, and then we will close the webinar. Do you have a question, Captain Andy? There are a lot of questions in the Q&A chat box, but I think our good speakers, our excellent speakers have addressed, and most of it actually, Dr. Melissa addressed the questions of some of our participants for this webinar. Yeah. And also Dr. Yang also addressed some of the question. Yes, but any question that you want to pose to our speakers, if you have one, Dr. Andy, Captain Andy.
Not yet. I think most of the questions have been addressed by our speakers. Yes. Thanks very much. I think, Anna, since we are already beyond the time, although that shows the enthusiasm of our audiences and the speakers, maybe I think we can close the meeting.
Yes. Okay.
And, also, I would also say just one point. That many issues have been touched upon. This is a serious meetings. So for the next round, I will talk about it with Anna. We are going to cover other issues that have been mentioned by our speakers. Thank you very much.
Yes, and also just for the information of our speakers and the participants of the forum, we are live in different social media platforms, in Facebook of the Manila Times, and even in my own Facebook page, and in GTNR Facebook page. This is a media entity as well. And thus far, we have a lot of people who watch and even stayed until now watching the whole webinar. In Manila Times, it reached up to 104 people, no, and I think it will be watched as you know, it's there already in Facebook, so other people can watch the replay. So this is really a very successful webinar thus far. And so let me close the whole forum to our distinguished and esteemed speakers, to my co-moderator for this afternoon's webinar, retired Captain Andy Tian, who is the founder and president of the Global Governance Institution, to the co-organizer of this webinar, the Asian Century Philippine Strategic Studies Institute and the Integrated Development Strategic Studies. These are think tanks based in Manila. Ladies and gentlemen, friends and colleagues, once again, a pleasant, almost evening already to all. The bilateral relationship of the Philippines has already reached to a comprehensive strategic cooperative relationship, which means that there's a deepening in the practical cooperation and managing of differences between the two countries. Concerning the differences between the two countries in the disputed South China Sea, I think what is important is the way to handle these differences. There's a need to continue to handle it properly by the governments of both countries, the Philippines and China. Both sides need to look at these differences with a proper perspective and must not allow these differences to overshadow the many good things and benefits that the deepening friendship, mutual understanding, and cooperation between the Philippines and China are generating and producing for the good of both countries and their peoples. The Philippines and China are close neighbors and are destined to be Asian brothers because of the geography, no? We cannot avoid that. It's really there. Thus, the two countries are brothers that need to get along together peacefully and cooperatively. There's so much to look forward to as we pursue to achieve mutual beneficial and win-win cooperation between the Philippines and China. And I think the pursuance of joint oil and gas development cooperation, or whatever possible cooperation that we can come up with in a creative manner in terms of utilization of the marine resources in the disputed South China Sea is there to unfold. I hope that both our governments will persevere in making all this happen for the benefit of the Filipino and the Chinese people. On this note, I would like to congratulate and extend our sincere thanks to all our distinguished and esteemed speakers for sharing their knowledge, experience, and ideas on this issue. And actually, not only on this issue, but on so many things. Actually, I've learned a lot from this webinar. I would like as well to extend my heartfelt thanks to all who attended this forum, both live stream on social media and also via Zoom. Likewise, I would like to recognize and express our sincere gratitude to the Manila Times for covering this webinar. The Manila Times is the official media partner of this webinar. Ladies and gentlemen, once again, thank you very much, and I wish you a pleasant early evening and relaxed weekend. So thank you so much, and hope to see you in our next webinar. We're arranging some kind of dialogue between the two parties, no? China and the Philippines, but this is much more, I think, people to people level, not the state to state, no, but people to people. So see you again in our next webinar. We will be sending invitation as well. Thank you so much.
Thank you.
Thank you.